Welcome to Infringe at Your Own Risk.
Hello and welcome to Infringe at Your Own Risk. My name is Kevin Rosenquist. I am here with Rand Bateman of Bateman IP, where we discuss all things intellectual property. Today we're diving further into patents. We've talked about them, but we're really going to unpack them this episode, why they matter, how they're used to protect and power innovation. Rand, welcome back. Great to see you.
Thank you. It's good to be seen.
So why are patents so important, especially for inventors and for businesses?
So the idea behind a patent is that society is going to make a deal with inventors. If you will tell us what you invented, we will give you a certain amount of time to have exclusive rights to it. And then you disclose that knowledge to the world. And if you look at the technological changes that have happened in the world since our founding as a country, they're really amazing. And basically from the early 1800s on, technology has just taken off because we build on each other. And patents actually have two different advantages. One is that bargain that we just disclosed. The inventor of something gets an exclusive right to use it, and then the public gets it. But the other advantage of it is if a device or a process, whatever it is very valuable, if it something companies need to compete, well, what do you do if somebody else has a patent on it? Mm-hmm. You design around it. You come up a way of doing what they're doing without infringing their patent. And that design around process likewise creates new technologies, because we stumble into things as we're trying to get around somebody's patent on X. We invent product Y, which may be a terrible replacement for product X, but for some other use, it may be, the best thing that we've ever seen. And so you get this synergistic effect of developing technology. And just in my career time, to see the advances that we've come. I mean, when I started practicing, or just after I started practicing, making something wireless was really cool. Mm-hmm. And we would get patents on turning things from being wired to being wireless.
Yeah, sure.
And now an examiner would laugh at you if that was your point of novelty, right? Because everything should be wireless.
Yeah,
right?
Nothing's really wired anymore.
We can charge our phone wirelessly.
Right.
We don't have to plug it in anymore. We can just set it on a pad or next to a pad, and it charges it. So we've had this amazing improvement in technology, and it makes people's lives better in a lot of different ways. So in the process of a patent, somebody comes and says, okay, I think I've invented something. And so the first step is usually you do a patentability search. And that is having somebody go and look and say, well, has anyone patented this before? And if you're a really big company, you start doing searches like online and other things. Has anybody done this before that didn't become patented? But if it looks like you've got something that's new, then you write up your patent. And what a patent is an explanation of the invention. Here's what I invented. Here's how it works. You have to explain to the public how it works, or how it's made, or what it is. And then the last part of the patent is the section called the claims, and it is the property description for your patent. In the old days, the property descriptions, you go way back, was from the oak tree to the river to the big rock and back to the road and then up to the oak tree. That was your property description. Mm-hmm. And now we have plats that we submit. If you're doing a subdivision, you have a plat and it shows where everybody's property is and what that. The claims at the end of the patent are similar in that, and they'll claim the device in words. So, for example, if I were going to claim a pickup truck, if I had invented a pickup truck, I would claim a frame having a plurality of wheels, an engine mounted on the frame, a plurality of panels to form a cab, and a box behind the cab to hold things, basically. Let's say that is a very, very rough patent claim for a pickup truck. And so that becomes, if no one had ever done that before, then I get a patent on that. And then when somebody else comes out with another car, then we say, okay, well, does this infringe my patent? So let's say they come out with the El Camino. Well, it doesn't look like a pickup on the front end, but it does have the bed in the back. And so depending on the exact words, they would go through and say, does this match this? So the examiner goes through the prior art, what other people have done, and says, does anything have this? That's called novelty. It goes through every line I write, and he says, does the prior art have it? No. Okay, it's novel. Then the next question is it obvious? So if I have the pickup truck and the El Camino is prior art, somebody else created that first. So hopefully everybody knows what an El Camino is. I realize that probably the Gen Z folks.
Yeah, the younger folks might not, but I think most people probably do.
Basically picture a station wagon where they cut off everything after the driver's seat and stuck a pickup truck on the back of it.
Yep. That's pretty accurate. Yeah. And some people make them into pools. It's very cool.
Yeah, they're classic now. They're worth a lot of money.
Absolutely.
If you want in good condition. But so if that were prior art, then the examiner may reject it and say, well, they're not identical, but all I would have to do is change the front end in this way, and that would be really obvious to do. And then I have your pickup truck. So it goes through that examination process. That can take, from filing the application to going through the examination process. Right now is typically taking 2 to 3 years in most areas. There's some fields of art, especially some of the electronics, where it's even longer than that. And then they accept it, you pay your fees, and boom, you have a brand new baby patent. And then you have to decide, okay, well, is anybody infringing my patent? And if they are, then you would sue them for infringement. And the judge or jury kind of does a similar analysis. They take your patent, the accused infringing product, and say, does it have this? Yes. 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 Has everything, it infringes. Or no, it doesn't have this thing. So in my icicles case, my argument was, let me go back. So if someone hasn't seen that episode, so I've got a case that's been pending now for 6 years where somebody has a patent for making ice structures out of icicles. So they, take icicles and then attach them together, spray them with water, and they do a big event where people come and look at these, pretty structures. My client, rather than using icicles, used a long plastic tubes, and then filled them with water, and then would use a chainsaw to cut them into pieces and then use those to build. And so one of the big issues in the case is an ice log an icicle? The jury says no, well, then my client wouldn't infringe. So they go through that analysis. And if it's yes to everything, then there's infringement. One of the other things, though, that the defense side is going to do is they're going to try and find other things that the examiner didn't consider to say, well, yes, you have your patent, but here's something that somebody else did that invalidates your patent. So that's the game that goes back and forth between the patent owner and the defendant in patent litigation. So what I've explained is a utility application, what's called a utility application. And I talked about the checking against an item, the same thing for a process. If it's a process for making candy bars, do they have a conveyor belt? Do they put down a layer of nougat? Do they put down peanuts? Do they put down a layer of chocolate? And you go through the claims and determine the accused device or accused process versus the patent. Is it all there? Yes, then there's infringement, assuming the patent's valid. The other side is going to be argue, no, this part's different than that part. And we have prior art that would invalidate that patent's claim. So patents can be very valuable because they are on a key part of a device. For example, if you had a patent when they first put GPS into phones, okay, that would be incredibly valuable.
Yeah, you'd be doing well. You'd be doing well.
Because that thing suddenly made phones, so much more than they were before. And so you don't need a really broad patent. You just need a patent on the features that the public wants. If the public really wants your phone to have a camera and you had a patent on a phone and camera combination, then you would make a lot of money. And really what happens with phones and whatnot is there are these giant patent pools, right? Where companies come in with literally hundreds, if not thousands of patents on a phone. And then they basically do licensing fees amongst themselves because there's certain things in certain industries. There's so many patents, you couldn't make a product that anybody would want without using other people's patents. And so the people with the most patents often get higher royalties, and the people with fewer pay higher royalties. And so there can be a rush to get as many patents as you can.
Can an individual get a patent? Can Kevin Rosenquist just get a patent, or do I need an LLC? Do I need a corporation? Do I need some sort of entity to do it?
No, an individual absolutely can get a patent.
Okay.
I've had many clients who have gotten patents, some of whom have done very well with it, some of which went nowhere with it. And the challenge is that inventors are usually not business guys, right? So the inventor comes up with a great idea. You need someone to take that idea then and then put it into the market. You've got to get a product made and on the shelf, or you've got to go license that product to somebody else, right? And that can be a great way to earn money.
Sure.
I was in a deposition once where somebody had invented something. They had a just run of the mill job, and were still in their job. 30 years later after they'd made this initial invention. We were talking, and one of the opposing counsel had kind of drifted back and was like this. And the person questioning, I says, "So how much you make in your? What was your royalty payment last year?" "Oh, a little over $1 million. They keep working me down." And this guy goes, "Yeah, because this guy who's just, nothing special about his job, just had a great idea on a way of improving his job, and it's now done across the country and in numerous foreign countries, the way you deal with this particular problem, and it's all copied off of his." And even though the people that had paid him had worked him down repeatedly on his royalty rate, he was still making over $1 million a year in royalties, doing nothing.
Yeah.
But he was just down home enough guy that he kept doing the same job.
Wow.
So
if I was getting $1 million a year in royalties, I'm pretty sure I'd retire. Just in case anyone out there is curious, that's what I would do.
So, but you see that. You see people who just found a little bit better way of doing something.
Mm-hmm.
And on high volume stuff, it could be something literally that saves a nickel.
Right.
If it saves a nickel every time on this one part, if you're selling 20 million of those a year, that nickel's worth a lot of money.
It's a lot of cheddar for sure.
So we get in small inventors who do things, and some of them want to build their own and sell them and do. Others will go and license it to somebody. Some of them start businesses, and then the businesses get bought by larger companies. So it's anybody can patent something. It's not cheap. It's not insanely expensive. The U.S. is good in that for what you pay for, you get a lot of protection. If you get a patent in the U.S., you're covering a huge market with it. Mm-hmm. Where there are some other countries that cost just as much to get a patent, and you're covering maybe 1/10 the people. So it's a good deal in the U.S., but it's not for the faint of heart.
Yeah. Is it a long process?
It can be. It depends. I've had patents that have issued in 4 months. That's very rare. And I've had patents that took 6 or 7 years to fight their way through the process.
When you were saying, and we talked about in a different episode about how there's just not enough people going over these things to expedite the process.
Yeah, I wish we had twice the number of patent examiners that we do, or 50% more that could speed this up, because in some areas it's really critical to have that patent ASAP, because that scares people away. If people come in then and start making money on it, they're more likely to be willing to fight your patent than if your patent's there before they start, because they haven't made the investment in competing with you.
Is that what a provisional patent is? Is that where you're in process?
Yeah. So a provisional application is it's kind of I analogize it to getting a wristband to get a ticket to a concert. Mm-hmm. So you file your patent application, you get your filing date is the day you filed that. Now, provisional, you have 1 year to file your non-provisional application. So if I file an application, within that 1 year, you can make any improvements you want. So you can go out, start offering it to people, and somebody can say, I like this, but it doesn't really solve this problem I have. You can go back and tinker with it. And then when you file your full application or non-provisional within that year, then you have, once it's in, that's what your patent's going to be based on. You can't add to a patent once it's filed. So provisionals are good that way. Where provisionals are dangerous is people will throw together really poor provisional applications and file them. And you'll see someplace online that says, I'll file a provisional for you for $300 or $500. And what that usually is they're just taking your notes and filing them. And too often there's critical things that you needed in that application to explain how things work or distinguish other pieces of art. And if it's not there, your patent application, your filing date doesn't do you any good. You have to go off the non-provisional filing date, and you're a year later and somebody else could have come in that meantime. And I've had that happen a few times where, the client just didn't have enough disclosure early on. So you want to make sure your provisional application is written. If it doesn't look like a non-provisional application, it's usually not worth it, unless you're going to a trade show tomorrow and you forgot about getting a patent. Then file whatever you can, because
just do whatever you can.
It shows that as of this date, I had this.
Right.
But it's important that you think it through and not just. I've seen people who have gone and filed their applications, and then they come back to me for a non-provisional. I say, okay, but just realize your provisional that you filed probably isn't going to do you much good, because there's just not the disclosure that needed to be there. Mm-hmm. So, but provisionals are important. They're less expensive. They're great if you suddenly remember the day before a trade show. I have had clients come in at 3:00 and say, we forgot we're disclosing this big invention we have at a trade show tomorrow. And I have taken an application at 3 p.m. and by the next morning had a 30-page patent application ready to file, and then promptly fell asleep on my office floor.
Probably. Needed a vacation after that one.
But with the provisional, people will take that. The other good thing for provisionals is if you're making incremental improvements over that year, file a provisional. Take the provisional, the first one you had, I made this improvement, do a 1-page write-up, whatever it is, and file that again, because the filing fee is not that big, but you're getting that date instead of waiting until your year mark. If you wait, maybe somebody else comes in and has that improvement filed before you do. So provisionals are good that way, but don't do a cheap provisional. They're rarely worth it.
Wow. Lots to unpack. Always get an attorney, that's for sure. Well, thanks for tuning in to Infringe at Your Own Risk with Rand Bateman. To explore more or connect with Rand, visit batemanip.com. Don't forget to subscribe to our channel. We got lots more stuff coming your way on all things intellectual property. Rand, always great having you. Thanks so much for the time.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.